Dear colleagues, thank you very much for the possibility to be also here. We will be here four in the panels. My name is Vačok. I am from Slovakia. I am a judge and teacher in the Comenius University in Bratislava. The co-speakers are D.Trzcińska from Poland, also judge. I start with Janos Ede Silagi, eh? No. Georgina. Yes. Georgina Kiss, okay, mistake. Judge from Hungary, sorry for that. I'm not very big a friend with technique. And the fourth member of our speaking team is Vomáčka from Czech Republic. Dear colleagues, I think it was very good idea to give our panel at the end, because usually administrative justice comes when everything is finished. We have the valid decision of which is in force of public administrative authorities, etc. And with these valid decisions, the participants come to the courts. For us, the life starts, but we have still the finishing of in formal law, the finishing situation in public administrative bodies. But in little bit time, it's legal history, but we can do from the legal history the legal reality, because we have not only the power to cancel the decision, to annul the decision and return the case back to the process, but what is the very strong in the position of the court is that we have the power to say the public administration how to work it, how to apply the law, and how we have the power to say this way is correct. And this is also not only the power of courts, but what is important, it's very big responsibility of the courts, also to public administration, which is very often connected or concerns from not only from lawyers, but from specialists from different areas. Okay, let's go to our contents of the last part. Our last part will have two parts. The first part will be it's boring part, introducing speech. Why it's boring part? It's boring part because of that, because my role is to say what our colleagues want to say. That's enrolled in the in their written opinions, and after that will be the interesting part and discussion. Yes, and after the first presentation, we will discuss the topics what are important for us. From my side of moderator, I have very big advantage because my plan for this part is to give the first question and finish the conference, yes. And because as the people, when I'm getting older, unfortunately, I have still less answer, but still more questions. That's about our panel. Okay, when we talk about the topics which we will talk today, there are the first thing or element is system of courts. When we talk about the system of courts, it's interesting to say that in Visegrád countries we have different styles of courts. In Slovak Republic and Poland, we may say that we have the specialized separate system of administrative courts, very similar system. In Slovakia, administrative courts of first instance, in New York, vojvodské správne súdy. Vojvodské správne súdy, extraordinary remedy, cassation complaint to Supreme Administrative Court. Very interesting situation is in Hungary. There are general courts, but in 3 instances. It's one instance more in compare with our system. And very interesting system, mixture system in Czech Republic, when they have the first instance court in regional court, in Slovak krajské súdy and Czech, and the cassation complaint extraordinary remedy to the Supreme Administrative Court of the Slovak Republic. And this is the first question about how to build the administrative justice in matters of environment, if we should have specialization, how many instances, and etc., etc. When we talk about the subject matter of reviewing, we might say that the subject matter of reviewing or judicial control is very similar. There are permissions, approvals, and etc. But what is different, and it's very interesting also that in Hungarian and Poland model, they annul the decisions from the beginning. In Slovak model and I think Czech model also, we cancel the decisions. What means that we cancel the decision, but from the view of the Slovak legal system, we are still know that we had the period in which the decision was valid and in force. The third question and topic is the length of the proceeding, what is also very important. And for me, it was interesting that, for example, Polish system is, in compare with Slovak Republic, very fast. That I think in voivodeship you wrote around 5 months, yes, for the decision. In compare with administrative courts in Slovak Republic, it's really fast. You wrote about 2 years. It's the same in administrative courts in Slovak Republic. Somewhere in the middle, yes. And it's also very important that to build the fast administrative justice. For example, I remember for one judge from Italy, and he told me that in Italy they could decide in 2 instances within 1 year. It's very good in compare with, for example, the conditions in the Slovak Republic. All our systems are built on cassation principle. It means that the courts are not the public administration body. They shouldn't replace the work of administrative bodies. They could only control the public administration. And if there is the problem in facts or in legal opinions, we usually return the cases back. But also interesting question is, and in some scientific opinions, that if the system is not very complex and long. The last thing what we are talking about is the thing of education. It's interesting from the education of judges. It's interesting from the papers of my colleagues and the same is in Slovakia, that we have the educational program, but mainly it's on the voluntary principle of the particular judge. And it's also a question if it's good, or if, for example, the judges should also have the systematic education programs for educating new trends and etc. That's of course we could say, and in the papers are a lot of information about proceedings, but in this time we will continue in written form. Okay, that's very short beginning and my presentation, and let's go to discussion about this kind of topics. We could start with specialization. If we check the specialization, that I also sent some questions. Okay, to my colleagues, and my first question to the colleague: if they have in the court the special panels for environmental matters, and what is interesting and special in Hungary they have also experts, and the courts could call for experts when they need to solve the specific questions. And my question for her: who are experts and how are the experts selected and chosen to the particular court proceedings? The general question: if there are special panels for environmental matters in the courts, and if there are experts, how it functions.
Thank you very much. Good afternoon, dear colleagues, ladies and gentlemen. First of all, thank you very much for the invitation, being here and be part of your conference and your research. So my question was about the experts. As I mentioned in my study, in Hungary, the administrative judges are not specialized for environmental law. But the problem is that in these cases, the main point of the solution of this case are about facts, and we have to decide about these facts with some special knowledge from the field of different sciences. I can admit that there are many administrative judges who are specially qualified in the field of environmental law, but this is not the same. So this does not mean that we also can understand scientist things, and therefore we can ask for the help of the experts. This means that these are approved persons, natural or legal persons, who are in an official database registered by the Ministry of Justice, and these are scientists with relevant activity, with relevant experience in very special fields of science. For example, biology, geology, they are engineers, and so on. And as a judge, we have access to this database. I can say that this is an online database and this is public, so everybody can have this information. And there are some main points about these authorized person, in which field they are active, how long experience do they have, in which territory they are working. And me as a judge, we can I can choose from this database someone to answer me the main relevant questions, which are very necessary to decide the merit of the case.
Thank you very much. And how is it with specialization of your panels in the court?
In our court, there are some panels where are judges with specialization, but only in environmental law. So these are colleagues who are coming from the, for example, from the authority. So before their judicial career, they were working in some administrative authority. So they have some knowledge about how environmental authority works. But this does not mean that this would be the same to get the knowledge of the science.
Hello, good afternoon. Thank you very much for the invitation. I would go straight to the first question, and the answer would be rather brief. No, there are neither specialized courts dealing with environmental matters in Czechia, nor dedicated senates, and obviously nor individual judges. However, perhaps I can elaborate on the topic just to describe what are the reasons behind that and possible consequences. First, compared to the criminal judiciary, I believe that the workload concerning environmental aspects is much more robust in administrative judiciary climbing over 5% or even more at the second level cassation court, which then makes the area rather relevant from the perspective of judges dealing with those individual cases. Nevertheless, they are not specialized, and I think the reasons are twofold. First, it is probably the recent historic experience, because between 2004 and 2014, the judges at the Supreme Administrative Court were semi-specialized. That means that several senates formed into the so-called collegium were dealing with tax law, and other judges in forming the second collegium were dealing with social security. That was not the exclusive agenda. It was an extra agenda to the general workload. This was abandoned in 2014 because obviously it rendered some disputes among judges regarding the difficulty of the cases. Some of those specialized in tax law complained that the cases are too sophisticated, too demanding compared to those social security. So it was after 10 years that the head of the court said, no longer you will be the universal judges. And the idea of universal judges remains until today. The second reason is that following this change, and also the rising workload, the judges at the Supreme Administrative Court are equipped with 3 assistants. So they are assumed to be able to tackle all those various fields of administrative law, including environmental matters. So these probably are the 2 main reasons. So there is not even debate on the specialization on judges. There is only one exception. The regional court in Ostrava is dealing exclusively with construction permits for large strategic infrastructure buildings. But also that is an extra agenda. It's not the only agenda the court is dealing with. The following question probably would be, does it actually impact the quality of the decisions? Is it that we sorely missed those specialized judges and we would like to have better quality decisions? I don't think that that's the question of specialization that much. It's more how much workload, the overall workload is there, and how much time do those many teams have to prepare for those environmental cases. Nevertheless, from my experience, if there is a groundbreaking case, then usually the judge suggests there is a press release, and there is also the ruling is then published in the so-called collection of important judgments. And this only rarely happens in environmental area, simply because the judges that deal with environmental cases are not aware that the case is of high importance for the practice. So that would probably change if there were specialized judges and could see what's the development of the area. Similar to the situation in Hungary, judges dealing with environmental cases can appoint expert, but this almost never happens. So the judges usually approach those cases from the position of this knowledgeable layman and try to solve it based on their general knowledge. And I believe there are only 3-4 cases in last 10 years that we actually had expert appointed. Sometimes it's very difficult. So, for example, dealing with noise, or I remember there was a case concerning radio broadcasting frequency. The question was whether this certain frequency at the borders of the country may actually interfere with air traffic. And it was very difficult to find an expert to say, well, yes or not. So based on precautionary principle, finally the court said there might be an interference. We cannot exclude it. So you will not be assigned this radio frequency. But still up till today, we don't know the solution. And that reminds me of, I'm sorry because this is more improvised. This reminds me of a case I've heard about. It was last year. We were in Finland. There were Finnish judges, and they discussed a case concerning bridge and traffic on a bridge and protection of bats. And the problem was that the cars going over the bridge 50 kilometers per hour were probably interfering with the bats. But the judges said, we have no idea whether there is any solution or measure that would be effective, but we ordered the speed to be lowered to 30 kilometers per hour. So at least to do something, to find a compromise. And we believe that it would help the bats, but no one, not even experts, will confirm that. So it is more using these principles of precaution or preventive measures and then seeing what actually happens in practice. And that, I would say, would be the last point. Thank you very much.
Thank you very much for the invitation and for the possibility to share with my research. Few words of introduction, because you said already about the standard of judiciary, administrative judiciary. In Poland, of course, we also have 2 instance courts. There are 16 voivode administrative courts, in one of which I work, and we have Supreme Administrative Court, to which the appeal cassation goes. There are no separate, no special administrative court dedicated for environmental matters, because simply environmental case is just an administrative case. So this is just a kind of the administrative case that we deal. So that's why we do not have any special panels for environmental matters, the same as in your countries. But we also do not have the possibility to use experts, unfortunately. You said that you have this possibility, but you actually don't use it. I think that if we had such a possibility, I can say from my experience, I probably would try to use it. We do not also have special proceedings that is dedicated for these cases. We have general proceedings in front of administrative power. And we also have, of course, general proceeding that is dedicated to the courts. That's the law on the proceedings before administrative courts. But there are exceptions. So if the provision allows, there are exceptions. For example, a motion for suspension of execution of the decision on environmental impact assessment. It's a very specific notion where it must be dealt in specific period of time. We have only 30 days. To hear it, and what is even more difficult, it must be held on public hearing. The general rule is that such motions are dealt on closed sessions. So this one must go to a public hearing, and it must be dealt within 30 days. That's quite a new provision. And some more data about the necessity of having specified judges or special panels. As you said, generally the rule is that in Poland, in first instance court and in second instance court, we deal in panels of 3 professional judges. In 2024, as I checked, we had in my court, so in Voivode Administrative Court in Gdańsk, we had over 3,600 cases, and out of which there were, what do you think, how many were administrative cases? 86, exactly. So that's even not 1%, even not half of the percent. So the question is, do we, as much as I agree that environmental matters are really difficult, are really complex, and really do need special technical knowledge, but if we have not that very huge number of the cases, do we really need special panels? That's a question for you. Thank you.
Before continuing, I would like to ask you, what do you think? We should build the administrative justice in the matters of environment, in the principle of specialization, or the court should make the general control of public administration with professional judges, but not with specialization only for environmental matters? What do you think?
You should
Should.
implement it, yeah. Not exclusively. So if they don't have enough cases, of course, they could decide on different matters. But if we have environmental case, in my opinion at least, that case should be assigned to this panel or one of those two panels specialized also in environment. Like in the Slovakian prosecutor system. My wife is specialized prosecutor for environment, but that's like 15% of our.
Okay, thank you for opinion, please.
But then the thing is, as Vojta mentioned, there's not only judges, right? There's also assistants, and each judge probably has a team of.
I have only one.
I have also only one. That's Czech. System is privilege. Okay, that's another opinions from colleagues.
I have a question then to my colleagues, because when we are talking about the specialization of the funds of the judges, what is the system of choosing the judges to the cases in your countries? Because in Poland, for example, it's like the case enters the court, and then we have alphabetic list of the judges, and the case goes by each one by one to the judge referee, which is first appointed. So there is, I don't know, but I don't see any possibility about the specialization, because each judges must get a case. Yes. So how does it look on your?
In my court, it is that we also have the same system. It is also basically how the judges get the cases, but there are two exceptions: tax law and environmental law. So this is ruled before. If there is a tax law case, there are three panels who can be addressed, and if there is an environmental law case, I think that there are two.
Okay, so I think that's a good solution.
Yes, we do have a similar solution that the Act on Administrative Justice states that the head of the Supreme Administrative Court may establish those collegiums that would specialize on certain matters. So it is not even restricted to specific areas, but it's basically up to the head of the Supreme Administrative Court, not the first level court, that it allows for specialization, and we would not need any amendment. Of course, for those specialized senates, then the workload would come and it would be randomly disseminated among those judges. So,
okay, in Slovakia we have the special program which decide which case go to the which panel. But the president of the court could decide that, for example, some kind of cases go to the part that some kinds of cases could go only to specific panels. It means that, for example, our presidents may decide that, for example, environmental matters go only to the panel 1 and 2. The condition is that it must be minimum 2 panels, because it must be yes, but minimum panels, and in this situation we could do something like partial specialization. But what is interesting, it's interesting also in which condition we work. For example, in Slovakia we have, according to the official statistics, in administrative courts as in the first level, the administrative courts in the year 2024 that decided 2,000 cases approximately, and also 63 were from environmental law. The problem is that, for example, in small countries, it's very hard to find enough work for specialized senates what is interesting, for example, was in the Supreme Administrative Court in Poland, there are around 150 judges. And what I remember from staying there, that they have very effective specialization for a lot of, but it's problem in small countries. And if the second danger thing is that if you give the power to 2 senates, give the power to 6 people, and 6 people will decide about everything in the field in the Supreme Court, and it could be very dangerous in the small courts to concentrate the power in the so close community. That's it's maybe the question, the thing of disadvantage. Maybe the questions for connected also with specialization is the second one, and I don't want to be the provocateur here, but what is was in fact environmental law? Yes, that's when we can say that I am specialist for environmental law, because when we see to the public administration, we couldn't say that we have specialists for environmental law. We are people who work with minings, with water, with cultural heritage. The environmental law is really broad, and it's for example, also in environmental law, very hard to say that I am good for, I don't know, marital law and also cultural heritage, because this is also could be the problem. That's also in environmental law. When we do our researches, we do researches in particular area. I don't know if you do research in all environmental law. Yes, it's also the second thing of specialization. What could be problem when we speak only about the specialization for environmental law? Yes, I remember one guy from Prague, and he talked that he wanted to create the Department of Energy Law. Yes, because it's a small part of environment connected with environmental law, but also very big part with a lot of problems. That's okay, maybe? Yes.
Just one observation when we're talking about the specialization, maybe we'll pay too much attention to the knowledge instead of paying attention to the general view of the importance of the environment protection. Because when we have done when we're trained in environmental matters, what we gain is that the understanding that the environmental protection is important. So when he or she deal with the environmental crime, it's not the crime, it's the environmental crime. So the accent goes to the first part of the crime. So it's not one of the many crimes, but it is environmental crime. That maybe this training will give us that power.
Mm-hmm. Okay, thank you.
Actually, I would say something from the point of view of prosecution and judiciary in criminal part, because as we have heard in the criminal judiciary panel, there are very low penalties imposed in environmental cases, and I say that it's because the judges are actually not good skilled in environmental crimes, and they are decreasing the value of these cases actually because they are not seeing the true value of the environmental protection. Actually, for them, it's like that's no criminality. We will impose lower punishment, and in comparison to other fields of crimes, it is still like that they give not so big attention to environmental crimes, like for example to economic crime, because environmental is something that is only around us and not so important, and in the middle is money and economic crime, and so that's why I think is the punishment level at the level as we have heard it in the criminal judiciary section. So that's why I think that maybe also in criminal justice, we need specialized environmental criminal judges and not only the civil environmental judges.
Okay. Mm-hmm.
But that goes to the broader question, like who's going to be the expert or who's going to be specialized in that? Because if you decided, let's say the Supreme Court, like now we will have 12 judges specialized in environment. I doubt that you will find 12 judges who are passionate about the environment. And it could end up like in Slovakia when they're establishing so-called environment police. It was like, hey, Johnny, you have 3 dogs. You're going to be environment call.
Okay. Please reactions if you want.
Yeah, it was like that. And some fights.
That's what the life's about. Actually, sometimes you just get the task and then you get the proper knowledge and you follow the further education and so on. So I don't think that this is a primary obstacle. And also, like determining that the scope of the environment law is more or less arbitrary. Always you have to find a line and draw a line. And certainly we can argue that there are very important environmental cases that are actually, for example, tax cases or state aid cases dealing with waste management facilities. Also, you need this proper knowledge of environmental law. But, well, it's about the workload and it's about who is responsible for which part. Always you can ask the experts that are more skilled, but it's just one case of many. So it's about how many cases do we have and whether that's going to change. That's one of the arguments. First in my country was that the decision-making will become cumbersome because only 6 people or 9 people were very responsible for the whole field. And that's I can't see Dr. Andauer anymore, but what we always say, look at the civil court, look at the civil Supreme Court. The specialization does not actually work that much because it's cumbersome. They are not likely to be flexible, progressive. It's not really working. So we don't want to introduce that. On the other hand, it's also about adjusting the system. So it would not be 6, 9, but perhaps 12 people or 15 people. However, the line will be drawn the different way. The second argument, of course, is that without this specific knowledge, you can't really, become an expert and so on. So I don't think that really matters. It's more about effectiveness, and then sometimes you just need to build from the ground up.
Maybe yes. I only one sentence. It's sometimes the question of numbers of cases. Yes, that's for example. Some people told me I want to go to administrative court because I like, for example, cadastral offices, and I want to decide in the matters of cadastre. And I know that this person won't do that in the administrative courts because this person will have this case 1 in 2 years. Yes, and that's the difference between, for example, judges and public administration. That public administration is really specialized. For example, they work with one statute 8 hours a day. In some cases, we have these cases maybe once in 2-3 years. Yes, that's the difference that what the justice can offer to the society can offer something like over control of the principles, of the main rules, and etc. But probably it's very hard if we wouldn't have courts in 1,000 judges, or I don't know, for a very strong specialization. Please, Veronica.
I just have a question that reminds me of Vojta, what you are doing, because you're an environmental law expert working at the analytical department of the Supreme Administrative Court. So my question to you would be, do you see that you actually influence that the judges who don't have the expertise in environmental law reach out to you and ask you for advice? And is it the case of Hungary, Poland, and Slovakia as well, that you have analytical department as your own human resources available at the court? And can you reach out to such an expert within the court if you don't have a chance to appoint an expert?
Please.
Oh, it was a question.
Yeah, I'm trying not to influence the decision. I'm just trying to present the law as it is, also the case law analysis as it is. But sometimes, of course, who wants to listens. So if there's someone that would like to dig a bit deeper into the multi-level system of legal regulation, then it's really helpful. And we are often approached by regional courts that need help with certain specific serious issues. So it's working pretty well, but it also shows that without this further knowledge or kind of cooperation and at least this basic service from the state, either from the court or from the ministries, the judges are not likely to keep pace with the development of environmental law. Not only is the field important, but it's also evolving quickly. So I'm quite happy that I know that, for example, my Slovak colleagues will publish a lecture book on environmental law, or maybe it's already published, because it's very helpful. Sometimes the judges need to have even this basic lecture book to have this knowledge. It's not basic, it's quite comprehensive. Yeah, very close.
Okay, please.
Well, in the end, I think that we as judges, we are supposed to be experts in environmental law, not in environmental science, and that's what you said. Although, of course, as I said, I would like to have the possibility to reach to the expert's opinion. But in the end, my role is to know the law, the environmental law, not really be great in scientific knowledge, yes, because I'm a judge.
Can I follow up? Can I have a technical follow-up? So where do you reach out for help?
We are cassation court. So if I don't find it in a case and the work that public authority did, I knew I can save the decision.
I just wanted to say thank you for your point of view, because in every opinion I found something to take away. First of all, what you said, that we have to focus on what we are dealing with, and this is the environment, which is the only one. This is our living area, so we have to take care about it. And in the second opinion, I really liked that you mentioned the passion. Because I think that without passion, we won't be able, so judges won't be able to get that relevant knowledge, as you also said, to learn more about environmental law. And this is also very, very important, because there is so difficult system in, for example, if we only have a look on the permissions, that it needs very, very high efforts from the judges to get known this system, and without any passion, we cannot solve it. And at last, I would reflect on Veronica's idea, but not now, but today morning in your presentation. I think also we need way of thinking, what you mentioned, that to need to take some inspiration also from the nature and find similar things, because these are also additional elements to be a good judge and to deal good.
Maybe only 2 sentences to the technical support. That's analytical centers and analytical centers and etc. And experts also. It's very important to, at the end, to answer the question: who should decide? If should be judge or experts or analytical centers and etc. And it could be really a big problem, because the experts' opinions couldn't be the decision of the court, and for the court it could be very hard to have argue with the opinion experts and tell no, the expert for waters doesn't have right, because our opinion, of course, legal opinion is in this way. And because of that, the first thing is, if we will push to the front the analytical big support, it could be the problem of authority of the courts, who in reality decide. The second thing, and this is returning the ball back to the public administration, is that for me, sometimes it seems to me that to go to the court is sometimes really comfortable, because I think that the real results should be created in public administration, because they are the professionals, not only for law, but for another environment. But of course, that's for ministries, is better to say, no, let's give it to the courts. And the court came here and decide about the disputes of mining experts. And mining experts weren't able to decide together. And the court must say that's okay. Your way of legal interpretation is, and because of that, I think the courts, according to my opinion, also should be something like ultima ratio for public administration. When the legality, and this is the problem, that's in reality it's not, it doesn't go this way from my experiences. Okay, any other questions? I don't know, rather you know. To the specialization, I don't know, do we have, it's time. Okay, that's, we have now many topics, but we have time. I would like to thanks a lot to my co-speaker. I would like to thanks a lot for you to help us to speak. And at the last sentence, and after that will be the official formal ending. I would like to go back to Veronica's speech in the morning. That I really think that in environmental matters that the law can help us, but we should start at the beginning in another fields of environmental education, etc. And the law should only solve the small problem in the society. Thank you very much, and thanks for your attention for our small group.